public session of the Florida Commission on Ethics will come to order. Secretary, will please call the roll.
Getting ready for this.
Here.
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 A quorum is present. Let's stand. Commissioner Gilzine will lead us in the pledge to the flag. I want to make just some preliminary housekeeping announcements. First District Court of Appeal lets us use these facilities, so we need to respect their rules and have absolutely no food or beverage other than water in the room. So please also silence your cell phones. Anyone addressing commission, please speak up so that our recording equipment can pick you up properly. And likewise, fellow commissioners, speak up and into the microphone so you can be heard. Members, I'd ask you to be as brief and concise as possible in your questions and comments, as we have a number of items for consideration. Pursuant to Section 286-0114 Florida statutes, members of the public have the opportunity to have input on matters before the commission other than in cases in which we act in a quasi-judicial capacity. This means the public can have input on matters other than complaints, opinions, and determinations in financial disclosure cases. If you desire to be heard, please fill out a speaker card and give it to Mrs. Fulford, who has her hand up in the back of the room, and you'll need to fill that out before speaking. Our last public session was October 21st. The minutes of that session have been circulated to you as members, and I assume they have been read. Does anyone have any questions or corrections to the minutes as circulated? None appearing. Do I hear a motion that we approve the minutes?
So moved.
Second?
Second.
All in favor, say aye.
Aye.
Opposed, like sign. That takes us to the, show it adopted. That takes us to consideration of advisory opinions. This is the consideration of opinion file 2791. Any public officer, candidate for public office, or public employee in Florida who's in doubt about the applicability of disclosure laws or standards of conduct to him or herself, or anyone who has the power to terminate other employees, may seek an advisory opinion from the commission about himself, herself, or that employee. Advisory opinions are based solely on the facts provided by the requester and are legally binding on the conduct at issue. The first one is file number 2791. It is involving a contract between the County Commissioner's Agency and employer reinstated pursuant to litigation settlement in Monroe County. Would the parties who are here on that matter please stand and identify themselves?
Schillinger, Monroe County Attorney.
Thank you. You'll be recognized in due time, if necessary. Steve, you are recognized.
Thank you, Mr. Chair. Commissioners, this opinion request comes to us from Bob Schillinger, the County Attorney for Monroe County. He made this opinion request on behalf of Holly Merrill Rashine, a member of the Board of County Commissioners for Monroe County. Mr. Schillinger and Commissioner Rashine are here today, and they are available to answer any questions you may have about the facts of this matter and to give you background on the opinion request. In this request, Mr. Schillinger and Commissioner Rashine essentially ask two questions. First, they ask whether Commissioner Rashine will have a conflict of interest if a now terminated contract between the county and her employer is reinstated through an agreement to settle active litigation. Second, they ask whether the parties can make certain amendments to that contract after it is reinstated. I will try to give you the facts of this matter in chronological order. In 2017, Monroe County executed a contract for disaster relief services with a company called Ashbrit. The contract was set for a 5-year term with 5 county options for 1-year extensions. Later in 2017, Ashbrit sued the county, and in 2018, the county terminated the contract for convenience. In 2020, Ashbrit hired Ms. Rashine to be its new Director of Government Relations. It's important to note that in that role, she is not an owner, partner, officer, director of the company. In 2021, Governor Ron DeSantis appointed Ms. Rashine to the Board of County Commissioners for Monroe County. June 20 of 2022 marked the date that would have been the end of the original 5-year term of that 2017 contract between the county and Ashbrit if it had not been terminated in 2018. On July 25 of 2022, Ashbrit made an offer to settle the litigation against the county and amended its settlement offer the following month. Contemporaneously, Commissioner Rashine won an open primary for the special election to fill the remaining 2 years of the unexpired term to which she had been appointed. That's the timeline that's in play for this request. Now let's talk about the settlement offer. Under the terms of the settlement offer, Ashbrit will dismiss all claims with prejudice and waive payments for additional fees, including attorney's fees. And the county will reinstate the 2017 contract and immediately exercise its 5 1-year options for 1-year extensions for a total of extension of 5 years of the contract. Under Section 112.313, subsection 7A, a public officer or a public employee will have a conflict of interest when they have employment or a contractual relationship with a business entity that is doing business with or is regulated by their agency, or when the employment or the contractual relationship creates a continuing or frequently recurring conflict between their public role and their private interests. There are 2 contracts that need to be analyzed in this opinion request once the contract is reinstated pursuant to the settlement agreement. We need to analyze the settlement agreement itself and then the 2017 contract that's being reinstated. The draft opinion analyzes the settlement agreement first. In the past, the Commission has opined that when an agency and a business entity are opposing parties in a lawsuit, that they are not doing business with each other through that lawsuit. Therefore, Section 112.313, subsection 7A would not create a conflict of interest between them just by means of the lawsuit. The draft opinion reasons that the settlement of a lawsuit is a necessary part of that lawsuit, and it also does not constitute doing business. Therefore, the draft concludes that the settlement agreement does not create a prohibited conflict of interest for Commissioner Rashine. The draft opinion next analyzes the reinstated contract from 2017. It is clear that once the contract is reinstated, Commissioner Rashine will have employment with a business entity, Ashbrit, and that entity will be doing business with the county through the reinstated 2017 contract. In past opinions, however, the Commission has found that doing business relationships between a public officer's agency and their private employer can be grandfathered when the private employment and the contract between the business entity and the county, or between the business entity and the agency, have both predated the public officer's appointment to public office. Past opinions have also said that renewals and extensions of grandfathered contracts will not vitiate the grandfathering as long as all other terms in the contract remain the same. In this instance, where the contract between the county and Ashbrit and Commissioner Rashine's employment with Ashbrit both occurred before she became a county commissioner, the draft opinion allows the 2017 contract to benefit from a grandfathering if it is reinstated, thereby negating the conflict of interest that she would otherwise have. Even if the contract is extended by the county's execution of all 5 of its 1-year options to extend the contract, all other terms will remain the same, and therefore the grandfathering will continue to exist and will not be vitiated. Therefore, it will negate the conflict of interest. All of that is question 1. Question 2 concerns all the same facts with some additions. In question 2, the additional facts are that the county would like to amend the contract to add some new terms. Generally speaking, FEMA reimburses local governments for certain disaster relief expenses. In order for the expenses of contracts like the one between Ashburn and the county to be reimbursed, the contract must include certain terms that FEMA wants. The terms are described in detail in the bottom paragraph of page 9 of the draft opinion, which is page 10 of the PDF that it was included in your materials. These terms are not necessary to make the contract enforceable, but they are necessary to be eligible for reimbursement from FEMA. I have been told that the reimbursement amounts are likely to be in the tens of millions of dollars, and that the county would have to forego reimbursement under this contract in the absence of these terms. I've also been told that the phrasing of these terms is technically negotiable. FEMA offers suggested language, but the parties could technically negotiate the wording. The county would also seek to amend the contract to add certain terms that are required by state law for any procurement contract. These terms are described in detail on page 10 of the draft, which is page 11 of the PDF included in your materials. Mr. Schillinger and one of his staff attorneys have both told me that it is their position and understanding that they would be required by state procurement laws to add these terms to the contract. The draft explains the history of the grandfathering exception to negate conflicts of interest. I'd be happy to explain that in more detail if you'd like, but briefly, since 2002, the Commission has repeatedly said that in order for a contract to remain grandfathered, once it is extended, the remaining terms must remain exactly the same. The draft recommends that the terms required by FEMA to make the county eligible for reimbursement will vitiate the grandfathering and create a conflict of interest for Commissioner Rashine if they are added to the contract. These terms are discretionary and negotiable and would change the terms of the contract by creating new rights and obligations for the parties. They would also create a new, huge business opportunity for Ashbridge by guaranteeing a third-party payer for the services. The addition of these terms would not leave the contract the same as its 2017 form. Turning now to the state terms, the Commission, to my knowledge, has never opined on amending a grandfathered contract to add terms required by law. The draft recommends that because the terms are required by law and they confer no added benefit to Ashbridge, their inclusion in the contract would not vitiate the grandfathering and would not create a conflict of interest for Commissioner Rashine. I just want to point out that Commissioner Rashine has been very eager in 2022. I think I first had contact with her in March or maybe February. She's been very eager to get ethics guidance and to learn her obligations so that she can be compliant with the Code of Ethics and all the ethics obligations, both regarding this matter and other matters. I wrote a letter to Commissioner Rashine in March of this year. That letter starts on page 16 of your materials. In that letter, I advised her on how to approach other ethics matters, like potential voting conflicts when the county votes on matters pertaining to this lawsuit. After I wrote that letter, Ms. Rashine, Mr. Schillinger, and I had a lengthy video conference, and we discussed the letter in even more detail. She understands her obligations to the Code of Ethics and has indicated that she intends to comply with the guidance in that letter fully and has expressed immense appreciation for the guidance. Lastly, there is one very small change I'd like to make to this draft. On page 3 and page 7, there are references to a vote in November pertaining to the settlement offer. It's my understanding that that vote was postponed until next week to make way for your consideration of this matter. With your approval, I'd like to change the references in November to reflect the December vote instead. I'm available to answer any questions you may have about the draft, and I offer it for your consideration.
Commissioner Waldman.
Thank you, Mr. Chairman. I just need to make a disclosure that I've known Commissioner Rashine since my days in the legislature. I consider her a personal friend, but that will have no effect on my participation and vote in this matter.
Commissioner Newton.
In full disclosure, I served with Commissioner and Representative Holly Rashine in the legislature, and I know to be an honorable woman, but that won't affect my voting on this matter.
Mr. Chairman.
Commissioner Gates.
While I was in the House of Lords, gone in the House of Commons, I did serve in the legislature contemporaneously with Holly Rashine, and want to disclose that, though I don't believe it will have an effect on my consideration.
Okay. Further comments or questions of Steve?
Mr. Chairman, I do have one question.
Yes.
What were Ms. Rashine before she was commissioner, and after she was commissioner? What were Commissioner Rashine's duties
What's the
for
name of the
Ashburn?
other attorney out there?
Did I understand that they were in the nature of representation, lobbying, or not? Did I misunderstand that?
Those, I have not been provided with the exact job duties of her position as it stands currently. She would be able to answer that, or Mr. Schillinger, but I don't have that information.
At the appropriate time, I'd like to ask that question of the parties.
Certainly. All right, Mr. Chandler, Schillinger, you're recognized.
So I want to thank you for the opportunity and address you here today. It's my first time here, so forgive me if I deviate from your normal processes. I want to thank staff, Steve, for giving great guidance, not just on this, but historically. The Ethics Commission staff has been as well served. Members of my body, my staff, always available. We always learn something when we call, so thank you for that. In answer to your question, her job description is provided was in the background materials. She manages and directs Ashburt's goals, successful client retention, target client acquisition, public relations with clients, potential clients at the elected and staff level is what is the top line of her job description. Now, she's here if you have specific questions, and we can have her answer those as to what specifically she does.
Mr. Chairman?
You're recognized.
It's a pretty simple question. There is a legal definition of lobbying. Has, in any way, shape, or form, in her duties and employment with Ashburn, has she been a lobbyist? Thank you.
So, thank you for the opportunity to clarify that. I hope that answers your question to your satisfaction. We appreciate the opinion. The draft opinion is wonderful in most respects. We'd ask to go a little bit farther and ask that you find that the FEMA reimbursement language that, yes, it's technically not required to make it an enforceable contract, but it is the industry standard. Both parties benefit from it. The public benefits from it. The public of Monroe County benefits from it because it would be able to get reimbursed by FEMA for expenses that it had already paid Ashbrook for, where Ashbrook called the service in the unfortunate circumstance if we had a hurricane. This is a disaster debris contract that only gets triggered when we have a natural disaster that's of sufficient magnitude that we can't clean it up ourselves. And the opinion speaks of, in the last page, of Ashbrook, and FEMA actually being a surety of Ashbrook. It's almost a surety of the taxpayers in Monroe County. So if I take any exception with it, and otherwise it's a very fine opinion and well researched and very thoughtful, I would ask that you find that those are really requirements, while not absolutely required by law, they're required by the circumstance, and treat them the same as the state law requirements that the legislature has imposed on public service contracts. That's my main ask here today. I'm happy to answer any other questions you may have.
Mr. Chairman?
Commissioner Gates?
Thank you, Mr. Chairman. I'd like to ask the General Counsel if he would comment on the request that's been made by counsel.
A grandfathered contract is like a golden goose egg. It's really a valuable thing. We get a lot of phone calls about contracts, and we often tell people it's grandfathered, and their contracts are grandfathered in certain situations. And then we very often get asked, well, what if And the what if is always a change that is substantial to the contract, creates new opportunities, or changes circumstances or adapts the contract to create to adapt in a favorable light to whatever the circumstances may be. We get asked this question a lot, which is why the commission went from a standard before 2002 where it would require that in order to maintain the grandfathering that the contract be substantially the same to exactly the same after 2002. And this commission has opined several times since then that exactly the same is the more manageable and correct standard to prevent conflicts of interest from being more pervasive in government. In this particular instance, where certainly I think he's right that the public might benefit from a reimbursement of funds like this. I think that that's entirely accurate. It's my understanding that, and Bob, correct me if I'm wrong, that it's not necessarily the case that there be one exclusive vendor for this particular service. It is possible, or potentially possible, that this contract could be reinstated, that if the terms were not in there such that FEMA would not reimburse this contract, that the current vendor could be retained, and the services that could be reimbursed could go to that other vendor. Services that might not be reimbursed could go to Ashbridge. That would settle the litigation. It would allow the contract to be reinstated. The taxpayers wouldn't notice the difference potentially. So there is, in practical terms, a context for that this opinion does not mean that the Monroe County and the taxpayers must forego all these reimbursement dollars.
Mr. Chairman.
Commissioner Gates.
Thank you, Mr. Chairman. So do I understand, as a layman, that what you're saying is that the opinion as written and as presented to the commission does not bar Monroe County from proceeding to claim this additional reimbursement so long as they resolve their litigation in the fashion that you described? Are you saying there is no barrier?
If Commissioner Rashine retains her position and her employment, and this contract is reinstated, and if the terms are added, the Ashbridge contract will not be able to be subject to reimbursement without creating the terms won't be able to be added to the contract for the Ashbridge contract such that they would be eligible for reimbursement through the Ashbridge contract. The reimbursement, jobs that would be eligible for reimbursement would need to be routed through another vendor that was eligible for reimbursement.
But the county would not be denied the effects, the positive effects of the FEMA payments, correct?
But that's my understanding.
May I respond?
Are there further questions?
You got a response.
Yeah, so,
I'm sorry.
may I respond?
Yes.
So the settlement would contemplate we would have two vendors, and if, based on workload issues, that's what happens. You get a storm, these companies are pulled all over the state, all over the country, all over the world sometimes. And sometimes one's more available than the other. We may not have the option or the luxury of flipping to the other vendor. We may have to call in Ashbridge because they're the ones who are ready, willing, and able to perform right then. We would still seek reimbursement from FEMA for the cost that we spent to Ashbridge because it's the same types of tasks. But FEMA may not reimburse us. They may look at the way this contract was written and not having the language that's in the federal super circular as part of the procurement regulations, may use that to ding us and reduce our reimbursement amount. So that's the clarification I would put on what council represented.
Yes.
Thank you, Mr. Chair. So, in response, though, to Commissioner Gates, while the county potentially could go to maybe get another vendor to do it, maybe not, in the instance where if we were to add this language, only the county benefits, Ashbridge would still be getting the money, so there's no benefit to Ashbridge, or certainly no benefit, I guess, to Mr. Shine as well.
Right, they wouldn't benefit any more. If we chose to use them, they're going to get paid by us, and then it's us seeking reimbursement from FEMA.
So only the county benefits in the event that we change the terms or allow the terms to be changed at this point, similar to with state law. If state law, we grandfathered state law, we allow state law to change the contract, and now, if I'm understanding correctly, this is in order for reimbursement, you have to change it due to federal law.
Yes.
So you want the federal law to be consistent with the state law grandfathering provision.
Yeah, we want it to be treated consistently with the state law changes. Yes, that's my ask.
All right, and just to understand, though, and to Steve, you say even with the change in the state law, there's a conflict of interest? Is Commissioner Rashine able to participate in any of these votes? Or, so nothing does it, this only has to do with whether or not Ashbridge can continue to contract with the state, the Concord Republic.
Yes.
And,
Yeah, two things about that. So on the voting conflict question, she is very adequately already advised on the voting conflict. I tried to quote some of the language from the March letter in the formal opinion so that you could see. Normally, I know you like to have me add cautionary language about that. She's already advised. It was well said the first time. I didn't want to trample on that, so I included it only for your benefit. So that's on the voting conflict. I want to be clear that I don't think this, if you drafted the opinion to say, to treat the federal requirements for eligibility for reimbursement the same as the state law, which is required just to even contract, I think there's if you word it that way and you treat them the same, that they're both required, you know, where where terms are required by law, then then we're going to allow grandfathering to continue. Her facts will need to match that. And if, in fact, these are not required terms to be eligible to contract or to make the contract effective, the opinion itself does not protect her from a potential complaint. It's easy to say as a matter of law, if it is the case that these terms are required by, not required just to be eligible for the money, but required to contract, which is what the state situation is, then, it's pretty clear that her facts are that on the state side. On the federal side, the terms are discretionary in as much as they are not needed to be there to make the contract effective. They're only required for the potential eligibility of the reimbursement. They may potentially be needed to get there. So they're in a different posture than the state law requirements. I wouldn't group them together, or if you decided to go that route, I would like to come up with a different reason for going that way.
Yeah.
I would not want to lump them in with the state law because I think that would be a mistake. It would not protect her.
All right, is there anything else? Commissioner Newton?
Yes. Thank you, Mr. Chairman. It's a good ethics commission day for me. People actually went to get an opinion before voting and getting in trouble and having conflicts. I thought I'd never see that happen. I just want to ask, and I understand where you're going. They currently have a protection of grandfathering. But if you screw with that, if you move it any way, it's not grandfathered. It's a new contract.
That's the way it's been treated historically.
I understand. I get that. I want to ask the gentleman standing here, what will prohibit them from the Monroe from going out and asking for an amendment to FEMA to get reimbursed for disaster pickup? And then my first one should have been, what's the difference between the 2017 contract and what FEMA is asking for today?
There's some language that would put in some termination clauses, termination for convenience. There's also some language on how you procure the contract. So it's the 2017 contract came out just as the federal government was updating they call it the super circular. It's this omnibus procurement guidelines for dealing with federal granting agencies. And not my area of expertise, one of my staff is, and I'm told that there are just some key technical language. They said, these are the things we want to see in a contract. And if we don't see it, we're not going to reimburse you for those expenses. Or that's an opportunity that they can say the contract wasn't appropriately bid and vetted, and so we're going to reduce some of your expenditures. We had a situation after Hurricane Irma where we had a vendor that we used, and we didn't have all of the language in there, and we didn't get, it's like a $6 million reimbursement got cut down to about $2.5 million, something like that.
Thank you, Mr. Chair.
Further questions or statements?
Mr. Chairman,
Commissioner Gates?
I'd like to ask a clarifying question. I apologize if this should have been obvious to me. If we approve the proposed opinion, advisory opinion as it's written, are we, what position is the county in with respect to FEMA reimbursement? Is it that they won't be able to use a particular vendor? Or is it that they won't be able to get the money in any case? Or is it, as I suspect, a political problem? That, you know, to borrow Commissioner Megg's phrase, we stay in our lane with respect to our opinion. But if you got a problem with FEMA, I've had some experience. FEMA can move this way or that way based on how hard the biscuits were and a lot of other things. That sounds to me like a lobbying problem and a political problem. It doesn't sound like our problem. Tell me I'm wrong.
I think it's a combination of one with a little bit of a flavor of three. So we may choose not to use this vendor because we're risking not being reimbursed. If you've dealt with FEMA, God bless you. You've dealt with the maddening shifting sands of how that works. And there's no telling how they will react once after a storm. They usually embed people with your EOC. They tell you, yeah, this looks good, and then the auditors get involved and you don't. And depending on how big an issue it is and how much you can lobby, there probably is a political component to that. We've been through Hurricane Irma. We've had the experience of getting, I'll use the word chiseled down, what we thought unfairly. Our taxpayers ended up having to just eat that couple million, $4 million of difference that they didn't reimburse us. So it'll affect how we proceed.
Well, that's baseball. Mr. Chairman, if it's in order, I would move the approval of the advisory opinion as presented.
Is there a second? Commissioner Newton, any discussion? Commissioner Wallman?
Thank you, Mr. Chair. Actually, a question to Steve, though. If you were to be able to carve out this FEMA exception, do you have language that you could propose? Because as we know, and we've talked about it many times here, every advisory opinion is specific to the person or the entity asking that question. Clearly, this contract with FEMA reimbursement benefits the people of Monroe County. And that's, I think if we were able to do it, I mean, that's our role here, and I don't think it's legislating. I think it's because there is no benefit to Ashbridge, there's no benefit to Commissioner Rashine, that I think if there is a way, I'd like to know if we've got it, and maybe there's support up here, maybe not, but how would you propose that?
Let me address your priors first. And identify what this problem is, why I would not want to lump this in with the state terms. The state terms, as we identified in the draft, there's no benefit to Ashbridge by adding these terms. They're all early termination clauses that cut against them, and obligations to not contract with Cuba and things like that. And with the state terms, they're not discretionary, these terms, they must be added. With the FEMA terms, I disagree with the idea that there's no benefit to Ashford. As Mr. Schillinger did identify, in the absence of this, they might choose not to contract with they might choose not to use this particular vendor for certain jobs, which means by making the carve-out that you're suggesting, it creates a bigger business opportunity for Ashbrook because they are more likely to get used because the job is reimbursable. Secondly, the terms are discretionary, unlike the state terms. So that's the identification of the problem. As far as carving it out, or the other part that you said was that this contract is of a particular benefit to the people, but most of vendor agreements with local government agencies or any government agencies are done because there is a public purpose for entering into the particular contract. So that would be a distinction without a difference, and we'd be not making a narrow exception here, a narrow carve-out here, but we'd be blowing a hole through grandfathering if we were to lean on the fact that there's a public benefit. That being said, I don't have a particular suggestion here because I don't think that the public benefit, drawing attention to that, is I haven't thought through language to make that work if that is the will of the commission. I would recommend that it be for some other if you're going to do it, that it be for some reason other than the vendor contract benefits the public, because I think every contract, nearly every contract would, and if there was a vendor contract that didn't benefit the public, that would be a very strange set of facts to bring forward and a very wild admission to make. So those are the thoughts that come to me in real time on that. I don't have the suggested language that you're asking for.
And then just one final question, if I might, Mr. Chair. Is the contract an exclusive contract?
No.
Further questions? All right, we have a motion and a second before us. All in favor, say aye. Aye. All opposed, like sign. Show it adopted. Thank you, sir.
Thank you.
That takes us to the next item, which is not a strange one to us. Item 5A, complaint number 21-001 and 21-178, and Ray Carla Higgins. Ms. Higgins' petition seeks to have the complainants, Mr. Thomas Walker and Ms. Jocelyn Reynolds, pay attorney's fees and costs to the following the dismissal of the complaint by this commission with a finding of no probable cause. We have copies of the file in this matter of the staff's draft of an order denying Ms. Higgins' request for attorney's fees. But on Wednesday, a response to the draft order denying the fees petition was filed by Ms. Higgins' attorney and is being passed out to you. At this stage, the petition is denied, and I am not aware. I'm sorry? If it's denied. And I am not aware of any time we have ever awarded attorney's fees. But if the petition is denied, the case will be dismissed. The final order denying the matter will be handled accordingly. If the petition is not denied, then the final order will be entered and the matter will be sent to the Division of Administrative Hearings for a hearing. Would the parties who are here please stand and identify themselves and the capacity in which they are here?
I'm Wayne Helsby, and I'm here in the capacity of representing the respondent.
Okay? All right, and,
Mark Aaron on behalf of Thomas Walker
Okay.
And Brendan Donnelly also representing
Okay. Well, we need to find out who's going to speak for who, but we're going to start off with Elizabeth Miller. You have seats, sir.
Steve's gonna-
Oh, Steve's going to make the presentation first.
Stephen Zilkowski, your General Counsel. Thank you, Mr. Chair. Kara Higgins is a member of the Board of Directors of the Florida Keys Aqueduct Authority. Recently, you dismissed 2 ethics complaints filed against her with a finding of no probable cause. After those cases were dismissed, Ms. Higgins filed a petition for attorney's fees and costs with the Commission on Ethics, and that is the first step to recovering attorney's fees and costs from the individuals who filed the ethics complaints against her. The first complainant of these 2 complaints is Thomas Grant Walker, a former executive director of the Florida Keys Aqueduct Authority. The second complainant is Jolynn Cates Reynolds, the director of engineering at the Florida Keys Aqueduct Authority. Essentially, the complaints alleged that Ms. Higgins was in a relationship with the then separated husband of Ms. Reynolds, Mr. Jim Reynolds, a gentleman who was seeking and was ultimately awarded a contract with the Florida Keys Aqueduct Authority through the firm he owned. The complaints allege that Ms. Higgins took public action in her public role to question and perhaps undermine the authority's award to a different vendor of the agreement in an effort to have the authority award the vendor agreement to Jim Reynolds' firm instead. Specifically, it's alleged that she questioned the legality of the agreement with the original firm and whether the award complied with agency procedures. She and the board voted to table the vote and to table the vote for the award until the staff could perform research on those issues. In response to the discussion at the board meeting, the staff rebid the contract, and the complaints allege Jim Reynolds' firm was indeed awarded the contract after the authority rebid it. The complaint from Ms. Reynolds was amended to include some additional allegations. Specifically, her amended complaint alleged that Ms. Higgins accepted gifts from Jim Reynolds, a vendor and/or lobbyist of the agency, while they were dating. These gifts were alleged to include trips, meals, and other tangible things of value. The Code of Ethics allows respondents to ethics complaints to seek attorney's fees and costs from a complainant in certain instances. We have a rule that lays out the process for recovering attorney's fees and costs. It's Rule 34-5.0291 of the Florida Administrative Code, and it states that the respondent must file a petition for fees and costs within 30 days of the dismissal of the complaint, and that the petition must supply facts sufficient to show entitlement to fees and costs. If the Commission determines that the petition is legally sufficient, it shall refer the matter to DOA for an administrative hearing. If the Commission determines that the petition is not legally sufficient, the Commission shall dismiss the petition. That's what your task here is today, to determine if Ms. Higgins' petition for attorney's fees and costs is legally sufficient and should be referred to DOA, or if it is not legally sufficient and should be dismissed. Section 112.317, subsection 7 of the Florida statutes lays out the standard for determining whether a respondent is entitled to recover attorney's fees and costs from complainants. There are 3 elements to making this determination. The first is that the complaint had to be made with a malicious intent to injure the public official's reputation. The second element is that the person filing the complaint had to know that the statements made about the official were false or were made with a reckless disregard for the truth. And third, the statements had to be material. To be clear, this is not a prevailing party standard. This is a very high bar for recovery. It's a very high bar for recovery because it is not intended to discourage complainants from bringing complaints that allege true material facts, even if the immaterial details are false or simply cannot be proven to be true. The law does not demand that every word and every little detail written in a complaint be verifiably correct and objectively true. Commission legal staff recommends that you dismiss Ms. Higgins' petition for attorney's fees and costs. The petition identified a number of statements made in the complaints by Mr. Walker and Ms. Reynolds that it contends were false. Even if those statements were false, the draft recommends that none of those statements were material to the decision to investigate the complaint to determine if she had misused her position under Section 112.313, subsection 6. Regarding the allegations pertaining to gifts laws, the fees petition states that Ms. Reynolds' statements in her amended complaint that Ms. Higgins received gifts from Jim Reynolds were false and that she should have known they were false. Although it is undisputed that Ms. Higgins received things of value from Jim Reynolds on shared vacations, you found that these things of value were not gifts because Ms. Higgins apparently paid more than half of the vacation expenses. The draft recommends that it is not clear that Ms. Reynolds knew these statements were false, given that she had access to Jim Reynolds' business records from the divorce proceedings, and those records contain numerous and substantial charges on shared vacations with Ms. Higgins. And Ms. Reynolds had no obvious way of investigating Ms. Higgins' financial contributions to the expenses of these trips. You are not obligated to adopt the draft order. This is just a document that is communicating the staff recommendation to facilitate your consideration of the matter. I offer the draft for your consideration, and of course the parties are going to have time after I speak to present arguments on the merits of the matter.
Are there questions of general counsel? All right, so then we go to Elizabeth there. Okay, who is? Mr. Helsey, you're recognized for a short presentation.
Thank you and good afternoon. Kara Higgins is unable to be here today. She has asked me, in the interest of brevity, to read to you a statement that she has prepared in response to actually supplement, the petition for attorney's fees. So with your permission, I'd like to just read that statement that she has prepared.
Please.
Here's her statement. I would like to thank the Commission for considering my statement and apologize for my inability to personally attend today's public session. I am a single mother of two young children, and I am their primary caretaker and provider. I do not receive any form of financial support from anyone else. I have owned and operated my own law firm, a solo practice consisting of myself and 3 non-attorney employees for the past 3 years. It is the end of my fiscal year. I'm attending a very important trial in Key West, and financially I simply can't afford to take another trip to Tallahassee this year, as it would result in further irreparable financial harm to my business, my employees, and ultimately my family. For the past 2 years, I have spent hours upon hours and full days from my business and my children defending myself and the Florida Keys Aqueduct Authority from a barrage of what I consider to be baseless, personal, and malicious attacks leveled by Mr. Tom Walker and Ms. Jolynn Reynolds. Mr. Walker's ethics complaint was followed by an internal Florida Keys Aqueduct Authority complaint by Ms. Reynolds, another complaint, ethics complaint internal of Ms. Reynolds to this commission, an amended ethics complaint alleging 41 separate counts of felony bribery, and yet another internal FKA complaint filed by Ms. Reynolds. Many of Ms. Walker's and Mr. Walker's and Ms. Reynolds' ethics complaints to this commission were summarily dismissed, as General Counsel noted, for failing to even allege a violation over which the commission has jurisdiction. The advocate, Elizabeth Miller, conducted an extensive investigation into the remaining allegations, and in her 25-page recommendation to the commission, she not only recommended dismissal of Walker's and Reynolds' complaints in their entirety, but she also made specific findings that my actions were, quote, reasonable and in the best interests of FKA and the taxpayers, end of quote. I've been severely harmed by the amount of time I've had to spend defending myself against this unyielding onslaught. As a member of the Florida Bar and a sole practitioner in a small community, I have suffered harm to my name, my reputation, not to mention the humiliation and emotional distress I have suffered by their very public false accusations. While I'm aware that I can't recover my complete financial losses in this forum, I'm asking the Commission to at least hold Mr. Walker and Ms. Reynolds liable for the costs and attorney's fees incurred in my defense of what I consider to be this vindictive and malicious action. I would like the Commission to know this about me. I have been an attorney for 24 years, licensed to practice in New Jersey, New York, Pennsylvania, and Florida. I'm a certified mediator. I have never had a bar complaint filed against me, nor have I ever filed one against another attorney. I've served 3 terms on the Florida Bar's Board of Governors, Young Lawyers Division. I'm past president of the Monroe County Bar Association. I am also past president of the Key West Chamber of Commerce and current president of the Key West Military Affairs Committee. I have sat on the FKA board since 2015. I've held other gubernatorial appointments. I currently serve on 3 boards, and I've always volunteered my time and money to local schools, my church, my Rotary Club, and other charitable organizations. I have worked hard to contribute to my community, build my business, and support my family. I've received numerous awards in both New Jersey and Florida for being a distinguished attorney and for my contributions to my community. The one I'm most proud of is the Athena International Award for achieving the highest level of professional excellence, improving my community and assisting other women in realizing their full leadership potential. I was never the subject of a complaint or a grievance until 2020, when I began dating Jim Reynolds. And I believe that my association with Jim is the only reason for the complaints. Mr. Walker was suspended without pay by Jim Reynolds when Jim was the executive director of the Florida Keys Aqueduct Authority. JoLynn Reynolds is Jim's ex-wife, who was involved in a very contentious divorce proceeding that began in 2019. I believe these complaints stemmed from their disdain for Jim, yet because of my position, they were able to misuse this commission to publicly harass both him and I asked this commission to not only read the words, but listen to the music in considering my petition for fees. To give context to Mr. Walker's and Ms. Reynolds' false accusations, it is relevant for the commission to understand that I began dating Jim after Jim told me that he was getting a divorce, which he ultimately did. We were completely transparent about our relationship. As for Mr. Walker, I moved for his termination when he was executive director, and he was terminated by a 4-1 vote by the board, the FKA board. It was only a matter of months after his termination that he filed these ethics allegations against me. In my view, and we set forth this in the petition, both Mr. Walker and Ms. Reynolds knowingly made false statements of their complaints. To be respectful of the commission's time, I won't address every false allegation today. However, I will provide some of the obvious examples of allegations that they knew were false when they made them, to meet the standard as articulated by the General Counsel. First, they claimed that I argued against their recommendation to contract with a company called K2M to perform inspection services for a new administration building being constructed by FKA. They claim that my actions resulted in the board rejecting their recommendation for my own benefit, and to have the contract instead be awarded to a company that Jim Reynolds co-owns, called AAIS. That is not true. The board never rejected their recommendation to award the job to K2M. As Advocate Miller's recommendation acknowledged, the truth is that I seconded a motion to table the issue to give them more time to come back to the board with a valid reason as to why they failed to go out for bid on a project that, in my view, was required by law to go out on bid. That's it. Advocate Miller found and reported in her recommendation that, quote, "My actions were within the appropriate scope of my duties," end of quote. Mr. Walker's and Ms. Reynolds' allegations that I caused their recommendation to be rejected, which is the whole basis for their complaints, is not even remotely the truth. The truth is that I seconded a motion to table an issue. They knew that their allegations were false when they filed them. Yet they filed them, in my view, in reckless disregard for the truth and out of malice. Their allegations were slanderous, malicious, and intentional, in my opinion. Walker and Reynolds also accused me of, quote, "exerting undue influence over other board members," end of quote, to have Jim's company, AAIS, be awarded the inspection services. This is also not true. There is absolutely no evidence of this, and Advocate Miller agreed. In reality, as recognized by Advocate Miller, my actions helped save the taxpayers over $200,000. They knew full well that this was a lie when they filed it. To me, they made this allegation, again, in reckless disregard for the truth and only to further harm me. Next, Ms. Reynolds made 41 separate accusations that I committed felony bribery by accepting gifts she knew or should have known I did not receive. When Ms. Reynolds filed her complaints, she was in ongoing litigation with Jim Reynolds in their divorce proceedings. And consequently, she had access to financial records to investigate her allegations. Had she performed even the most cursory of investigations, she would have found, as Advocate Miller did and reported in her recommendation, that, quote, "I did not receive something of value from Jim Reynolds because it was established that we shared expenses, with me paying equal or more in compensation," end of quote. Advocate Miller's recommendation also found that I appropriately, quote, "recused myself from any official involvement with Jim Reynolds," end of quote. Ms. Reynolds knew I had never voted on or was involved in any decisions whatsoever regarding Jim Reynolds or his business. She was present at all the meetings where I recused myself on the record. In my view, Ms. Reynolds knew her accusations of felony bribery were completely false when she filed it, because she knew that Jim Reynolds and I were in a consensual, personal relationship well before Jim Reynolds was even a vendor for the Florida Keys Aqueduct Authority. She knew that our dinners and our trips were personal and not the result of some bribery scam. All Ms. Reynolds had to do was to ask Jim for receipts to verify her beliefs. All Ms. Reynolds had to do was to use common sense. Obviously, if Jim Reynolds paid for airline tickets out of state, yet did not pay for hotel accommodations, who did? She should have known that I, too, contributed to trips we took together if she had any interest in telling the truth. In conclusion, there's literally no basis for Ms. Reynolds, under oath, to accuse me of felony bribery to this commission. The seriousness of her accusations and the possible consequences to me should not be overlooked by this commission. As a lawyer and a public officer in a small community, my integrity and the community's trust in me is paramount. Ms. Reynolds misused this commission to publicly assert these false accusations and baselessly attack my credibility in the community. She should be required to pay attorney's fees and costs that were spent to have these false allegations dismissed.
Sir, your time has expired.
I'm about done.
Give you 30 seconds.
Okay? I ask that the commission not allow Ms. Walker and Mr. Walker and Ms. Reynolds to walk away from the needless harm they've caused without taking personal responsibility for their actions.
Thank you, sir.
Thank you.
All right, Mr. Herron, for a hopefully brief presentation.
I see the clock's still running in the red zone here.
It'll be reset. Let the record show that Commissioner Wallman and Commissioner Gilzine have exited the meeting, but we still have a quorum of 6 people at the moment. Okay, the clock has been reset.
Thank you, Mr. Chairman. Members of the commission, Thomas Walker and Jolynn Reynolds observed what they perceived to be unethical conduct. They took action. They filed complaints with the Commission on Ethics. The Commission investigated those complaints. And like most complaints that are investigated, the advocate recommended that the commission find no probable cause. Now, apparently the advocate made some editorial comments in her recommendation that the counsel for Ms. Higgins is trying to use as a basis for seeking fees. But the commission agreed with the recommendation to dismiss the complaints with no probable cause. Now comes the respondent, Ms. Higgins, seeking attorney's fees allegedly incurred in the defense of the complaints. You should know a couple of things. Mr. Walker lost his job with the FKAA as a result of his disputes with Ms. Higgins. Ms. Reynolds was fired from employment for filing the complaint with this commission. You heard counsel for Ms. Higgins tell you that she's the most upstanding person in Monroe County. She has this award, she has that award, she serves on this board, she's an attorney, blah, blah, blah. What he didn't tell you is that this upstanding person is engaged in an adulterous affair with her husband while they're married. That's not necessarily a good public official. We submit, as does the staff, that there's no entitlement to attorney's fees just because the complaint is dismissed. There's no automatic entitlement. The statute authorizing respondent in an ethics proceeding sets a very high bar, as the staff told you, for a recovery of fees. The elements of a valid claim for costs and attorney's fees under Section 112.3.137 Florida statutes are, first, the complaint was made with a malicious intent to injure the reputation of a public official. Every complaint filed with the commission has the capacity of injuring that person's reputation. So that's why there's additional requirements in the statute. And the person who filed the complaint knew that the statements made about the official were false or were made with reckless disregard for their truth. Mr. Helsby filed a petition. The staff noted that there were deficiencies in the original petition for seeking fees, in the sense that there were no allegations made in that petition that indicated that the statements in the complaint were false or made with reckless disregard. They talked about they were reckless, they talked about they were false, but there was no allegation specifically as to either Mr. Walker or Ms. Reynolds that the the allegations were false. And the third requirement is that the statements made were material to this commission's investigation. A number of the statements that Mr. Helsby cited that were in the complaint were deemed not to be material. And I've been here seeking attorney's fees, and I've been told by staff and this commission that all this other stuff that they allege that your clients did, or your clients were alleged against your clients, were not material. And that's the case here.
But they can speak.
They weren't material. So the petition for attorney's fees, and the other thing I need to point out is now Mr. Helsby has filed, in essence, what's his reply, which sets forth additional information and additional allegations. And in his statements today, he basically tries to fill in the gaps which the staff has noted in its proposed final order with respect to the complaints. Let me point out to you some of the deficiencies which the staff recognized when they reviewed the petitions. And again, they are neutral in this point of view. They do not have a dog in the hunt on my side. They don't have a dog in the hunt on Ms. Higgins' side. They are looking at them through the lens of a neutral observer and what they've seen in the petition. And it says, notwithstanding Higgins' use of conclusory terms in the petition, such as false, reckless, and misrepresentation, the fees petition in question here fails to substantially allege that the above allegation was known by Walker to be false or was made with reckless disregard for the truth. The petition does not allege that Walker had access to information that directly contradicted this allegation or that he could have discovered where to access such information. Walker was entitled to invoke the investigatory processes of this commission to determine whether Higgins' actions as a public officer had resulted in a benefit to Mr. Reynolds. On its face, again parenthetically, on its face, a situation worthy of inquiry under Section 112.3136, close parentheses, whether that was violative of the statute. Under the cost fee statute, it is not the responsibility of a complainant to predict the commission's ultimate disposition of a complaint, that is, that it was dismissed. They made the same statements with respect to Ms. Reynolds' petition. And they also looked at the allegations about the gifts that Mr. Helsby sort of suggested in his remarks that Ms. Reynolds should have gone to her husband, who was engaged in this affair, or to her husband, as well as to Ms. Higgins, who was engaged in this affair, and said, hey, tell me who's paying for these trips you're taking with my husband. The other thing that he referenced to you is that there was this contentious divorce proceeding, and that she could have had access to this information through those proceedings. Well, there was a lot of contentious divorce proceedings, a lot of contentious discovery disputes, and a lot of records that were not timely provided in the course of that divorce. So, again, Mr. Helsby suggests that, well, should have asked him, is he paying for gifts? And again, the staff, looking at the complaint, with no bias involved, says, however, upon looking at the complaint, it is clear that Reynolds investigated the financial affairs of Mr. Reynolds to the best of her ability, period. Reynolds had access to Mr. Reynolds' financial information from divorce proceedings and was able to discover that trips were occurring in the first place from social media. The petition touches on Mrs. Reynolds' failure to conduct even the most basic research or investigation into Mr. Higgins' own expenses, but fails to elaborate on if or how Reynolds would have obtained Higgins' private financial information. Accordingly, Reynolds did not fail to investigate, and the petition does not substantively allege that Reynolds made the allegations knowing that they were false or with reckless disregard for the truth. There's only so much a complainant can do. And in this case, the staff has concluded that both Mr. Walker and Mr. Reynolds did the best they can when they saw that there was what they perceived to be unethical conduct. I would like to point out also in our response, we note some of these issues. And it says, only knowingly false allegations or allegations made with reckless disregard of whether they were false may entitle a respondent to fees. Legal conclusions or opinions based on true facts, even if incorrect, do not qualify one to receive fees. And we cite a court case, wasn't necessarily an ethics case, but we cite a court case where the court distinguishes between opinions based on true facts and libelous statements based on fact, holding that opinions based on true facts are not libelous, nor are they made with reckless disregard for the truth. The facts here do indicate that, again, what Mr. Walker and Ms. Reynolds perceived was unethical conduct, and unethical conduct in an effort to get a contract to Ms. Reynolds' former husband, or husband at the time, former husband. They may not have got everything correct, but that was the reason that they filed the complaints. That's the reason the staff concluded that these were worthy of investigation. And that's the reason that the investigative process goes forth, and sometimes they validate the facts that are alleged in the complaint, and sometimes they don't. So with respect to we would urge the commission to reject the petition for attorney's fees. This is clearly, in my view, again, another example of a slap administrative proceeding. Mr. Walker and Ms. Reynolds are asking this commission to penalize them for bringing a matter which they believe was unethical conduct to this commission. That shouldn't be the result, and we'd ask you to dismiss the petition for attorney's fees. Thank you.
Thank you, Mr. Herron. Are there any questions of Mr. Herron? All right. Are there any other speakers? I think we've heard from everybody. We have before us a suggested motion from staff that we deny the petition, then if we vote to deny the petition that has been presented, then the matter is done. If you, in fact, want to have substitute motion, send it to DOA, that's another thing. Steve, you have presented a motion, but I think somebody needs to make that motion.
Just a step.
I appreciate the promotion, but I didn't get to make a motion. I've only given you a draft order for your consideration.
Okay.
One of the members of the board can make a motion on whether or not they want to adopt it, or
Okay.
if they want to go in a different direction.
Mr. Chairman.
Senator Gates,
Thank you,
Commissioner Gates.
Mr. Chairman. Mr. Chairman, I move to dismiss the petition for attorney's fees and to accept the recommendations of general counsel.
Is there a second?
Second.
Is there discussion? All in favor, say aye.
Aye.
Opposed, like sign. Show it adopted. Is anybody here on that?
I'm not sure. I just worked through the
The next item is consideration of advocate's recommendation to dismiss complaint. Millie, is anybody else here on that?
I'm here, Mr. Chairman.
Okay, thank you. Okay. All right, Ms. Miller, you're recognized.
You're recognized. I'm sorry. She didn't hear you.
Oh, you're recognized.
Oh, thank you. I'm so sorry I didn't hear you. Elizabeth Miller, advocate for the commission. The Miami-Dade Financial Disclosure Coordinator alerted the Commission on Ethics that Michelle Kligman had not filed her 2017 CE Form 1. That was in 2017. She was placed on the list by the financial coordinator for one or two reasons. That would be that she had spending authority over a specific amount. That statutory authority in 2017 was $20,000. Or that she was a local officer pursuant to the definition in the statutes. The commission conducted an investigation once the complaint was received, or it was self-initiated, actually. There was no complaint. The news came in from Miami-Dade. In June of 2021, I came to you and asked for a probable cause finding that this particular respondent had willfully failed or refused to file her 2017 CE Form 1. You did find probable cause on June 9th, 2021. In preparation to send the case to the Division of Administrative Hearings for a final hearing, I sought witnesses or a witness who could testify that this particular respondent had the obligation to file under one of these two categories as a local officer, or she had a specific spending authority. No one could testify to that. Miami-Dade did their own investigation, and they could provide no one who could say why Ms. Kligman had to file her form. You will see attached to the motion to dismiss, Ms. Kligman's supervisor filed an affidavit or submitted an affidavit stating that Ms. Kligman did not have the requisite spending authority and did not fit under the definition of local officer. In conclusion, it was discovered that this particular respondent did not have to file. Therefore, I would ask that this complaint be dismissed for lack of jurisdiction. Thank you very much.
Mr. Herron?
I don't intend to take any time unless there's any questions, but I would join her recommendation.
Okay, do I hear a motion?
Yeah. Move it be dismissed for lack of jurisdiction.
Is there a second? Second. All in favor, say aye.
Aye.
Opposed, like sign. Thank you. Anybody here on that?
No, these are just staff.
Okay, we now get to financial disclosure extension request. And Myra Warman, extension request 22-08. It's a request for an extension of time in which to file financial disclosure. The law gives the chair the authority to grant extensions of 45 days, but only the commission can grant a longer extension. This is the second request for an extension by Mrs. Warman. A draft order recommending the request is in your hands. If you have any questions, Kathy can present her recommendations. Otherwise, I'm happy to accept a motion. Is there a motion?
Mr. Chairman,
Yes.
this may not be the motion you want. I move that the request for second extension be denied.
Second.
Okay. Is there discussion? All in favor, say aye.
Aye.
Opposed, like sign. Show it adopted. All right. That next takes us to consideration of final order rescinding financial disclosure fine. This is item 8A, and Gray will present the presentation. This is regarding Reginald H. Johnson.
Thank you, Chair. This is essentially a bookkeeping matter, rescinding a fine that's been imposed that should not have been imposed in the first place. Mr. Johnson is an employee of the Miami-Dade County Public School System. In 2018, the school district included him on the list of annual financial disclosure filers, so he got some notices reminding him to file a 2018 Form 1. He was tardy in filing that form, and because of his tardiness, he accrued a financial disclosure fine of $1,500. Now, a year ago, in December of 2021, you entered a default final order against him requiring him to pay that $1,500 fine. And apparently he's entered into a payment plan with the commission, and he started making payments on that fine in April. Now, all that concerns the fine that he accrued for not timely filing his Form 1. Separate and apart from that, the commission self-initiated a complaint against him to see if his failure to timely file was willful. As you know, if a filer incurs a $1,500 fine for not timely filing their disclosure, the commission by law is required to initiate a completely separate proceeding to see if their failure to file was willful. Willful proceedings are separate and apart from the fines that a disclosure filer might accrue if they don't timely file their form. So here, a willful proceeding was brought against Mr. Johnson. During the course of that willful proceeding, very similar to what you've heard from the advocate just a few minutes ago, she came across some information that he should not have been included by the district on the list of filers in 2018 because he didn't have the requisite purchasing authority to be considered a filer. So the Commission's advocate verified that with an affidavit from the school district, presented that to you in the context of the willful proceeding during the last meeting, and based on information, you entered an order dismissing the willful complaint against Mr. Johnson for lack of jurisdiction. So that handles the willful proceeding. But we still got this $1,500 fine and an order that was entered against him for not timely filing the form. That's what we're here about this afternoon. Because he shouldn't have been included in the list of filers in 2018, his fine for not timely filing the 2018 form needs to be rescinded. Otherwise, you'd be fining him for filing a particular form late that he never had a responsibility to file in the first place. So the order in front of you now asks for you to rescind the $1,500 fine against Mr. Johnson, and I'm happy to answer any of your questions.
Do I hear a motion?
Yes, Mr. Chairman. I move that we rescind the fine for untimely filing with apologies to those.
Is there a second? All in favor, say aye.
Aye.
Opposed, like sign, show it adopted. Thank you, Gray. Now, this takes us to a matter that we normally don't have on our agenda. It comes up once a year, and that is consideration of our 2023-24 budget. There are still a lot of unknowns. We are not quite sure what action we may need to take in certain areas. We have not received marching orders from the legislature, but we decided to put this on today's agenda because it's something that has to be publicly noticed. And it needs to be done before our next meeting, and we didn't want to have a special meeting as we did last year. So it is here. I have talked on multiple occasions at some length with our executive director. She has done, I think, a very excellent job. You know, there are things like we don't know when our truck's going to blow up. We've got a truck, it's delivery trucks. How old is it? 20 years or something like that. And so those are some kind of unknowns. But I don't want to rush through this. But I just want to tell you that I have gone over it with Carrie, and I am very satisfied that she's done a very excellent job in presenting it. And so she's going to present it in a fairly brief form because of the lateness of the hour, but feel free to ask any questions that you have. And then we need a motion to adopt that as our proposed budget for the coming fiscal year. Carrie, you're recognized.
Thank you, Mr. Chair. In front of you today are the materials that were sent to you in a supplemental mail-out. Those materials are really what I would consider a rough draft of what a part of the package that I will be submitting to the legislature once they let me know what their expectations are and what the guidelines are. So these numbers are somewhat fluid, but will be largely the same as what you're seeing. So what I'm asking you for today is your feedback and supporting concept of what I would move forward with on behalf of the commission. This is really what most would term a continuation budget. There are a few items of note that I want to specifically call out and discuss with you to make sure that I have your support. But first, a little bit of background, just as a reminder. We are administratively housed within the legislature. Staff are legislative employees subject to the joint personnel policies of the legislature. As with all agencies, we get instructions related to our budget request for 2023 to 2024, and once those instructions are received, I will assemble the materials. Usually the turnaround time is pretty quick, so there would not be time between that time and the time they're due to have a commission meeting to do this work. I work closely with the Office of Legislative Services and their accountants and fiscal folks down there to assemble the necessary information. They will be providing that to me soon once they are told by the House and Senate what they are expecting. They help me to verify calculations and numbers, which I appreciate because I am not an accountant. Historically, the commission has received the appropriation it has sought. We've not had to lobby the legislature relating to our budget requests. We receive a lump sum appropriation as a part of the annual budget, both for the commission itself as well as the executive branch lobbyist trust fund, which we're also in charge of. The budget requests are broken into three categories: salaries, OPS, and expenses. For today's meeting, you have in front of you a fact sheet that is a 4-year look. When I send it downtown, they ask for a 3-year look. This is based on information I currently have and the anticipated agency needs. Again, some of these numbers may change a little bit as I have to make adjustments as we move forward. I will also make adjustments based on particular feedback received from you today. The carry forward document shows how the commission has categorized dollars from taxpayers into salary, OPS, and expenses. Any leftover monies from a particular fiscal year go into a carry forward budget, which the commission can, with permission, use for one-time non-recurring expenses. Often those expenses are not anticipated. You might recall at a previous meeting I sought your support for a carry forward request related to the Attorney General's contract. And we took that to downtown. So that will ultimately appear with the information we've put before the legislature. You'll notice no significant differences in budget requests year over year. The commission has remained relatively steady in the way that it manages its funds. We always work to be good stewards of the taxpayer dollars. We do tend to come in under budget. Most years, unspent budget goes to vacancies that we've had in the office where we've had accumulation of funds that weren't spent. The particular fund challenge that I have in budgeting is we're second half of the fiscal year heavy in terms of our expenses, because second half of the year is when we have our financial disclosure fund. So I get my magic 8-ball out and my crystal ball a little bit and work with these numbers. So let's first talk about salaries. I do want to let you know, as I continue to work with these numbers for investigations, that number should reflect 703,617. I knew something wasn't sitting right. That makes that total $2,046,529 anticipated. The amounts for salary are grouped by section. Actual salary numbers may vary based on more up-to-date information that will be provided to me later. There is a notation there of a personnel plan, and I want to talk about that a little bit. The personnel plan amount includes for the upcoming fiscal year funds for a new attorney position that Steve and I would like to add at that time if our needs remain the same as what we seem to see the trend being. We previously had a vacant attorney position. Last spring, Steve and I opted to convert that to an admin position in anticipation of some e-filing needs. And so we want to bring back an attorney position and fund that so that that attorney can help us with, as you've seen, our growing litigation list, the increasing efficiency of our investigators, as well as any Amendment 12 increase in complaints we might see, and any potential additional workload from e-filing. So if you all approve that, I will put that through, and if we are funded for that, we would be able to fill the position July 1. Other items included in the personnel plan include funds for potential merit or retention increases as appropriate, any additional insurance costs that come up if employees who currently have single costs, update to family costs, and importantly, funds related to an issue that we touched on in our meetings here and there since I've been executive director, and that relates to our investigator salaries. As I mentioned, we're subject to joint policies for legislative agencies when it comes to personnel, and under the current position and salary structure requirements, the ethics investigators, not senior investigators, but ethics investigators must have a bachelor's degree and 4 years of investigative experience. Master's degree can substitute for 1 year of the required experience, or they can have 8 years of investigative work experience to substitute year for year for the educational requirements. With that, the base salary is $37,928. Our hiring base is a little bit more than that. We've had zero luck successfully hiring at that base amount. We've reviewed other investigative positions at other state agencies, and that has shown us that investigative positions requiring a bachelor's degree with no experience hire at around $37,000. With a bachelor's degree plus 4, the hiring range tends to be between $45,000 and $52,000. Further, my review of a salary study done on investigative salaries that was conducted by another state agency shows that investigators who are in their current position with that agency for 3 years or less are averaging roughly 23% more than our commissioned investigators. That kind of disparity makes it difficult for us to hire competent investigators who can do the work that is required and the kind of investigations and writing that is required to be an ethics investigator. It also presents a challenge for us to retain our investigators and meet our retention goal after we've made that training investment. To me, this is a no-brainer. With the Commission's support, I'd like to seek funds to address this issue. It would not be a merit increase. It would be an increase to protect the Commission's training investment and its human resources. The goal would be to be able to be competitive enough to hire solid investigators without creating disharmony amongst the staff we currently have. It'll be a small change that will make a very big difference in accomplishing the key component of the Commission's mission. So with your support, I'm going to seek permission to increase our budgetary funds so that we can increase our hiring base while commensurately increasing by the same amount salaries of investigators in relation to that base. I believe that I can do that with a minimal increase to the salaries budget, and I would hope that you would support our efforts in that regard, but I'm interested in your feedback with regard to that. Moving to the OPS category, the largest budgeted item in there obviously is the Attorney General's contract. The Attorney General's contract covers our fantastic advocates as well as a paralegal specialist position in their office and the expenses related to running that office. We did have a request from the Attorney General's office that we add some additional funds to that contract for the 23-24 fiscal year because the Attorney General's office is seeking to increase the salaries of their attorneys, and I would certainly be in support of that. I know they're having the same recruitment and retention issues that many of us are. There's also a contract in there that relates to other legal services that can be provided by the Attorney General's office. That contract was utilized earlier this year with some rule challenges, so that is in there as well. We also have a line for the temporary part-time OPS workers that we have helped us during financial disclosure season. We'd like to keep that going. A couple of things to note with those items. I had a suggestion made to me by one of our members here that I have a discussion with Buff and Melody, and I've been speaking to them previously about what their needs might be, given the workload of the commission and the increased efficiency of investigators as we've sought to improve our case management. And through that discussion, I'd like your support to add some additional funds to the Attorney General's contract so that they can add another paralegal to their staff. Buff and I are talking about that and speaking to the folks who supervise her to find out exactly what that would be and what that amount might entail. But I think that would be very helpful to them in terms of keeping the cases moving. They've indicated they don't need another attorney at this time, but we believe that another paralegal might be helpful to them. In addition to that, we've had a really successful legal intern program that Steve brought along. It was a great idea. We've had I believe, a summer and a fall intern. Fall and spring legal interns work for free. They get credit in their classes, but summer legal interns are paid. And so I would like to increase that line so that we can afford to pay a summer legal intern the rate of $15 an hour for 30 hours a week. So I would like to do that. Another item that is a new item under OPS is a training category. We haven't had a training category for the professional development of our own staff in a number of years. I would like to add a modest amount of $4,000. I think it's important that we keep our skills sharp. If we identified an appropriate writing course, if there was a need, or management course, if there was a need, I would like to have the flexibility in my budget to be able to send someone to that. That leads me to expenses. Expenses often remain steady. In your materials, you had a draft contract list that identifies our main contracts. Attorney General's Office, Westlaw, those are our biggies. Also in that contract list is the lease, the Commission's office space. I think the chair mentioned at the last meeting that our lease for office space will expire this summer, and we would very much like to stay in our current space. Under the circumstances, it does meet our needs. There is some additional space downstairs. We did need to expand and take that. So I've been in contact with the landlord, and we hope to work towards a proposal, work with the chair, so that we can bring a potential lease agreement to you all for consideration. So obviously, the lease amount will change. The amount that you see in there now is the current lease amount I would expect. It would be my hope we could negotiate a multi-year lease that would be agreeable with both parties and agreeable to you. That will come back to you later, and I hope to have some preliminary numbers on that soon. Also, a large item in our expenses tends to be postage. Last year, I reduced the amount in the postage, anticipating that e-filing was happening. E-file did happen, and then it paused, and so we had some expenses in mailing and postage that we didn't anticipate that we would have. So I'm looking at the reality that we may have exceeded that particular line this year, but we should stay within our particular category. In terms of the budgeted amount, the good news there is that last year, with your budget approval, you asked me to seek approval for the use of carry forward funds for any unanticipated costs from e-filing. I think that would fall in that category if we wind up having any issues there. COGO memberships are in there. Also attending the COGO conference next year. The conference will not be in Canada. It will be somewhere in the U.S. I don't know where exactly at this time. I like to send as many folks as I can there. I kept that amount at $6,000, and I hope to send a few of us there. The travel in-state budget tends to be for investigations and member travel to meetings. The other item that I wanted to talk to you about today relates to the commission vehicle. We are currently the proud owners of a 2007 Ford Focus four-door wagon. It's parked out front. We affectionately refer to it as the Ethics Mobile. But we purchased it in 2006, so it's over 15 years old. It replaced a 1993 Dodge Caravan. The Focus has over 98,000 miles on it. We've kept up with maintenance over the years. Honestly, it looks better than it runs, and it doesn't look good at all. So that's not a compliment. It's not particularly trustworthy, so we don't have investigators take it out of town anymore. We use it to make these meetings happen, bring all of the things that we need here for the meetings back and forth to the office, also to the post office, also to downtown, to pick up and drop off things or any meetings as the need dictates. Of course, that vehicle is only used for official purposes, and we keep logs on its use. It currently could probably use a couple of tires. The tires might cost more than the car is actually worth. From our research, it appears that according to DMS, we could purchase a vehicle that in the current market, some sort of similarly sized wagon for around $30,000, which gives me great pause because that's a big number to me. I'm hoping that cost could come down by the time we would buy in the summer. I would like to replace the vehicle. It would be a vehicle that we could use not only for our in-town needs and for meeting needs, but for our investigators to be able to take on investigations, or our legal staff or myself be able to take it when we conduct trainings outside of Tallahassee. My go-to would maybe be to request the use of carry-forward funds to purchase that vehicle. In the alternative, if you all did not want to do it that way, but were willing to purchase a vehicle, I would ask permission to add it to our regular budget. So with that, I will pause so we can discuss the commission's budget, and then I will be happy to move on to the executive branch budget, which is a lot more simple than the one that we have. I do intend to also ask your support in seeking the use of carry-forward funds from the legislature for things that arise out of the relaunch of electronic filing. We don't know what we don't know. We didn't make it all the way through a filing season last year with Form 6s. There could be additional things that run into next year we will have to deal with for Form 6, and it's very possible, given that the launch date is for Jan 1, 2024, for Form 1s, that there will be some contracts that need to be put in place for augmenting staff. Those contracts would likely exceed my expenditure authority. They would come back to you, but I won't know until we kind of get to the mid-year mark, and that will be after the appropriation is made. So I'm happy to answer your questions. Just to recap, it looks like $2,046,526 for salaries, and it as a general number, $522,045 for OPS, plus an additional for the paralegal with the Attorney General's office, and then for expenses, it's going to come in around $266,000 for expenses. The DOA number is not yet known. DOA provides that number to us. The legislature, once they get DOA's request, they slide that number into our budget. It's just done as a budget transfer. The number you see here of $66,884 is the amount we're paying currently for this year, so I just put that in there as a placeholder. Any questions?
Are there any questions? All right, Commissioner Gates.
Very, very quickly, Senator. First of all, in my experience, they're usually shooting the tires out from under agency heads who want to spend more money. In this case, I think we have a very conservative agency head. I want to compliment her. I will support the budget. I hope that the investigators' salaries are not just competitive, but are at the high level of competition. We want the best investigators we can get, and you get what you pay for. In many cases, we have been getting more than we paid for, and I don't think that that can be sustained, as you pointed out. Secondly, I think that as you and others have pointed out, we have a greater litigation burden and litigation expense than we've had in the past. And so this is a question. If we need, because of the litigation burden, do we have the ability, if necessary, to add someone on an OPS basis or on a contract basis, a hired gun to go do some of the additional litigation? Is that able to be done, A? And is it, if so, do you need budget authority? Do you have budget authority for that?
Through the chair, we do have the additional legal services for attorneys. We have that contract with the Attorney General's office. So it is possible that we could work under that contract to get other attorneys in the Attorney General's office to assist us with litigation on an as-needed basis. I am not sure at this moment how much money we would have left in that current item within the OPS category, but it should not be entirely spent based on what we did earlier in the year. That number unfortunately escapes me at the moment. So we could activate that in terms of contracting. Other than that, we don't have any other money in the OPS category for contracting. We would have to seek carry forward funds, permission to use carry forward funds, or I guess you're more familiar with this than me, some sort of budget amendment to get something in there so that we could execute a contract and get that additional help.
Mr. Chairman, knowing that the Attorney General's office is also short of litigation staff, it might be tough to get a litigator from there if we needed it. We've got two great advocates here, but if we have a litigation burden that is greater than can be reasonably carried by our current players, I would think that you'd want to include, in your ongoing budget, not using carry forward funds, but include as an operational matter an amount of money necessary to get, a contract litigator on an as-needed basis, not somebody just to be around forever, but somebody on an as-needed basis outside of the Attorney General's office. Not because we don't like the AG, we love her, but because they're having trouble getting staff as well. And then finally, Mr. Chairman, I just wanted to say that, being in business myself, I know the travel expenses are going up. I think that you'll be unpleasantly surprised if you don't increase the budget for in-state travel as well as out-of-state travel. Now, particularly when we, have a greater necessity to move complaints along through the process and be efficient, we want to be able to make sure that if travel is necessary, that it be done. So I would support and encourage an increase in in-state and out-of-state travel. And the other thing is, add the vehicle, don't use it out of carry-forward funds. Occasionally, a state agency has to buy a vehicle. My old rule was, when your vehicle has as many miles on it as the one I drive, then the agency can ask for more vehicles. And I can tell you now that you have a lot more miles than I have on my Ford Flex. So please, just buy the vehicle. Get her done.
Okay.
Very good budget.
Thank you.
All right, further questions?
Could I just make a comment?
Sure.
Where were you when state attorneys were coming before you? Asking for money?
Well, you know, Commissioner Meigs, that I have a long and positive relationship with the lobbyist for the State Attorneys Association, and so I can say this, it was because of him that you had problems.
And we shall report that to him. Question?
Yes.
Regarding the real estate, we're under a lease now, and if so, when does that lease expire?
That is correct. We have been in our current building since 2013, I believe. Initially, it was a 7-year lease. There was a provision for a 3-year extension that was exercised, and it expires June 30 of 2023.
So that's coming up.
Yes.
It's just a concern I have, having visited the office several times. You can't get in this building without going through security. I can get off the elevator and just freely wander around where you all work. I don't know that that's the best way to be, but perhaps in the lease renewal negotiations, that hallway would support lockable doors on either end of that hallway. Y'all are just completely exposed to any crackpot that, and we have controversial cases here. So
We see that.
I'm just an observation I've made every time I've walked in there.
And through the chair, I appreciate that. We did have a security analysis done a number of years ago where they made some easy recommendations. We have some mirrors up. We do have the ability to lock our elevator to where, we have to send it down, but I'll definitely speak to the landlord about.
Could be easy on that one, the other each side of the elevator to put lockable doors that you have to have access granted from inside. It's just,
We do have walk-ins from time to time.
Yeah, we think, yeah.
Sometimes related to ethics matters and sometimes related to other things in the community. So we'll definitely talk to them about that. Thank you.
All right, let's move to the executive.
All right.
Be a lot quicker.
Moving quickly to the executive.
Do you need a vote on this budget or not?
We can do a vote at once at the end, or we can vote on this now.
Whatever you want,
Whatever.
Mr. Chairman.
Well, my intention was to take up the, both budgets in one vote.
Okay, then through the chair, I'll move quickly to the executive branch. You have the same fact sheet, so I won't belabor what that is. Obviously, we are in charge of the Executive Branch Lobbyist Registration Office. It's co-located in the Pepper Building with the Legislative Lobbyist Registration Office. We split costs with the legislature based on the number of registered lobbyists. Currently, the commission split is 48% of the cost. The funding of the office is not taxpayer dollars. It comes from the lobbyist registration fees of $25 per principal, plus the late registration reports that cost $50 a day, in fines up to $1,500. Registration and compensation reporting, of course, is done electronically. We have one employee who functions as the commission's registrar. She is fabulous in her work on behalf of the commission. She independently runs that office and initiates any action that needs to be taken. We're in constant communication with Karen Murphy Bunton about a variety of issues in that office, and we have the ultimate trust in her. I have written some funds in the personnel plan to reflect that and hope to add that to the salaries budget. Under OPS, the largest budgeted amount is for accounting services. That is what we use to pay the lobbyist audits each year. I will tell you that last year, in the OPS budget, I saw an additional $20,000. I think it's currently at $40,000. I saw $60,000, and the executive branch lobbyist budget actually came in about $20,000 less than what we had requested for the fiscal year. That did not alarm me, based on my understanding from previous years that lobbyist audits, some years they wanted paid out of carry forward, and in some years out of OPS was my understanding, and that if we fell short of the amount, we would use carry forward. The reason for that is the lobbyist audits that are conducted each year, it is difficult to anticipate what those will cost, because it's dependent on which lobbying firms are randomly chosen during the drawing, the random selection of audits. So some years, if it's smaller lobbying firms, that amount's going to be smaller. We're not going to spend all the money we have in there. And other years, they're going to be bigger lobbying firms. The more lobbyists, the more cost. I will tell you, $40,000 in that line item this year, we blew right through that. And I sought and been granted permission by House and Senate to use carry forward for that. So this year, I am requesting $70,000 in that particular category just for lobbyist audits. I've talked to the person who handles the legislative lobbying side of things, and that's consistent with what she is requesting as well. And hopefully we get what we need there. That is the major item that I have increased the amounts for the credit card fees that we have to pay because people register online, they pay their fees online, their fines online. We get assessed credit card fees, and I want to make sure that we're able to cover that. For the rent at the Pepper Building, of course, that's managed by DMS. If there's any increase in that rent, they will provide administered funds. You might note in the operating budget there's a grade area of numbers in the executive branch. Those numbers are provided by the fiscal office downtown once I submit the approved, the commission's proposed budget. So the numbers in the gray area here are from last year's submission, and those will change as well. And that's all I have for executive branch. I would ask you to support those recommendations, and I'm happy to answer any questions that you have.
Are there questions? Is there a motion that we accept the two budgets?
So moved.
As amended by Commissioner Grant, or Commissioner Gates, excuse me.
Yes, yes. Second?
I'll second.
Discussion? All in favor, say aye. Aye. Opposed, like sign. All right, that brings us to a rapid, almost close. Reports, Chair's report, I have no report. Executive Director, she said so much today, I don't know that she's got anything else to say.
I'm sorry to say I have reports. I will be brief. Let me first officially welcome Joe Burns as our newest staff attorney. Please join me in welcoming him to our staff. Joe is a military veteran and joined our team on October 31st from the private sector, where he practiced primarily in the area of insurance defense. In the month he's been with us, he's already drafted orders, opinion letters, worked on some preliminary willful investigation review, and he's demonstrated a great aptitude for our subject matter, and so we're happy to have him on board. Also joining our investigative team this week is Marian Lambeth. She's seated out in the gallery. Welcome, Marian. She's an experienced investigator and experienced public servant. She has previous experience with the Department of Education Investigations Unit related to educational practices, I believe. And she's already been assigned a case and is preparing to travel on that investigation. And based on her experience, she's already had at least one good idea that's been passed along to me that we're looking on implementing as another investigative tool. So we want to welcome them both. Keith and I leave for Kogel tomorrow, Montreal, at dark 30 in the morning. We are looking forward to the professional development with our peers and the idea sharing and species recognition that goes on while we're there. And I will segue into the fact that I recognize from discussions on cases earlier today that there might be some legislative items that you want to discuss. We'll agenda those for the next meeting, which brings me to everyone's favorite topic, and that is e-filing. We are less than a month away to go, or go again. This is for Form 6s. There will be at least 3 of our staff members working on this on January 1, when we flip the switch, so to speak, and turn it on. Last year, we had over 800 disclosures that were filed prior to the pause of the system. I'd be remiss if I didn't speak to the complications of pausing and restarting the system. It was difficult, to say the least. It's more complicated than flipping a switch. We had to revert to our old system, and although we'd hoped that we'd be able to pause and work within our new system, that wasn't possible. So we had to shut down, revert to the old system, which is something we didn't anticipate having to do. The data, there are data issues moving back and forth, so there have been a lot of logistical and technical challenges with getting it ready to run again. I will spare you those details. We are remigrating the data. That can create other issues. It's a heavy lift, it's complex, and every change or fix can create new challenges. With the relaunch, Jan 1, 1,600 agency coordinators will be quick to log in when we're back in the office after the holiday to certify their list of filers who were serving in office as of December 31, 2022. This is what gives us that official filers list that lays the foundation, the groundwork for our entire filing season. There are over 38,000 filers total. About 2,500 of those are Form 6 filers. The tech team has made a number of modifications and enhancements and bug fixes to that coordinator part of the system based on our experience and our feedback last year. So we hope that goes a little more smoothly initially. We do plan to offer 2 webinars for those coordinators in early to mid-January to help facilitate getting their lists done, because we need that before the filers get in. We did it last year. Kim was great, and she's back by popular demand. Even though 2023 is not an election year, straight out of the gate, Duval County has an election. That means beginning Monday, January 9th, we will be working to make sure that any person who wishes to qualify for a Form 6 office that week will be able to do that utilizing the electronic system. Kim has already been in communication with the Duval County Supervisor of Elections. We are prepared to communicate with the office holders in Duval County who are set to qualify for re-election. They are going to get their registration invitations straight away the 3rd of January, so they can immediately hop in and get going and file their disclosure with the commission. Non-incumbent candidates who do not otherwise file financial disclosure, they'll be able to self-register and utilize the system to complete their disclosure. They're not financial disclosure filers, so they're only completing to qualify. So they complete the form electronically, but they don't submit it. They print it and take it to their qualifying officer. If they win, their information will later be incorporated into our system. The Form 6 is the same form that filers are accustomed to filing. It's just the way that they're filing that's different. As with last year's electronic filings, a tax return cannot be provided in lieu of listing income. When disclosing assets, they will be able to upload an Excel spreadsheet of their assets for people who have a great deal of assets. That was something that people wanted, and we delivered. The system has a template for that and a short video how-to on how to do it. In addition to that, there's a responsibility for filers not to provide account numbers, social security numbers, or PINs. We don't ask for those. There's a warning throughout the system that they not provide them, because if they provide them, they're going to show up when they submit it. There is a provision in the law where they can contact us, and we can redact those inadvertent disclosures, but that it's possible that won't occur prior to the immediate publication of the form. In response to the legislation that was filed last year seeking to require the system to allow document uploads, we have worked to make document uploads a reality. Although the feature will not be ready for rollout Jan 1, the tech team informs me that we can expect to begin testing that feature in January, targeting a rollout for sometime in February. It would be the plan that feature be there before all of the filers come in to register to file their disclosure. It creates a lot of complication in the system. It creates a lot of additional work on staff, but it was something that people missed. It was something that people wanted, and clearly they demanded it. We heard them, and we're working on it. I want to again thank Kim and Lynn, who've spent thousands of hours working with the tech team, conducting functional testing and user acceptance testing, and helping to troubleshoot the issues and bugs that come up prior to the launch. We're working on perfecting our communication to filers and coordinators, supervisor of elections, training videos, webinars being planned as we speak. We will provide concierge-level customer service that everyone has come to expect from us to the officials and candidates as they get acquainted with our system. And we hope everyone will exercise patience and good humor with us as we work to address any wrinkles as they come up. And I promise I am done talking. Thank you so very much.
All right, thank you very much. That brings us to the end of the agenda, so Commissioner Newton moves that we adjourn, but don't anybody stand up. All in favor, say aye. Aye. Opposed, like sign.